Question number 25 asks what are the remedies for breach of a contract, what is meant by damages, what is the principle underlining it. So, due to breach of contract by the defaulter or defaulting party, the aggrieved parties suffered loss and could claim damages in form of monetary compensation. The purpose is to retain the previous position of the aggrieved party, and general damages means the contract broken directly by a party, so the other party suffered direct loss. For an illustration regarding general damages, A to purchase 50 bags of rice at rupees 200 for bag from B, but on the day of delivery, B refused to deliver the same. So A purchased those 50 bags of rice at rupees 300 for bag from the open market. So A is entitled to claim monetary compensation from B as it is a general loss to him. And regarding special damages, loss arises on a special circumstance, so it is a kind of special loss, so it is a special damage. As for an illustration, B. Order for supply of fodder into a cattle fair with the railway company, but it does not reach in time. Due to delay, B could not sell fodder in the cattle fair, so here he suffered both general and also special loss, which we can say the profit he could have got by selling the fodder. So this is called as special damage. And regarding the third one, exemplary or vindictive damages, here it is a kind of loss of reputation, goodwill, or credibility of the party. So, in such circumstances, if the court feels can impose damages, its objective is to punish the defaulting party. And regarding that, we could discuss an important leading case, Jefferson versus Pascal, where there was loss of money, so it hurts the very emotion of the girl by the defendant, and the very reputation and social status of the family and the girl was hurt. Besides ordinary claim, the petitioner could claim vindictive damages. And in the same way, another important leading case, that is Addis versus Gramophone Company, where a bank trader's check was bounced in spite of having sufficient money in the account without any valid reason. So the trader's credibility is lost in the market. Besides general damages in form of vindictive or exemplary could be claimed from the bank through the court. And another form of damages, that is the nominal damages, where the aggrieved party, even though not suffered any loss, only have to recover a small amount, and it would be a warning to the defaulting party to maintain discipline in business industry, and as an illustration, he has to purchase 50 bags of wheat at Rs 200 per bag, but be refused on the very day of delivery. So B A found at the same rate from another trader. So here only the court could issue an reasonable or nominal damage to the aggrieved party. And now we'll go to liquidated damages. This is the specified sum as estimated loss in case the contract broken and it itself is there in the contract as estimated by both the parties in the contract. And in liquidated damages, the court cannot increase or decrease as the amount already decided by both the parties. And now we'll go to the very provision that is provided under question number 26, that summarize the rule governing penalty and liquidated damages resulting from breach of contract and distinguish between the two. So, Section 74 of the Indian Contract Act 1872 provides regarding penalty. And as we know, penalty also decided by both the parties in the contract. But here court has the power to reduce the very amount as it is already fixed in the contract. So, the amount can be reduced by the court if it is disproportionately or unreasonably high. And regarding the very distinction between liquidated damages and penalty, in India there is no such distinction between these two. But under English law we found such distinction. As regarding liquidated damages, the very purpose is to save the aggrieved party from the loss he suffered. But in case of penalty, this is to force the defaulting party to perform. And regarding the very amount